Hello everyone, welcome to LawPutra YouTube channel, and today we will be discussing documents of which registration is compulsory under Section 17 of Registration Act. My name is Advocate Akshay Sharma, so let's begin. Now Section 17 basically deals with documents which must be registered. That means the registration is compulsory. And Section 18 gives a list of documents whose registration is optional. And if a document which requires registration under Section 17 is not registered, then we'll turn to Section 49, which deals with effect of non-registration of documents which are required to be registration. So this was just a very brief overview that these three sections have to be, whenever you read Section 17, always go through Section 18 as well as Section 49 as well, so that you get a complete understanding. But in this video, I will be limiting to just Section 17 only. Now, Section 17 gives a list of documents which need registration, whose registration is compulsory. So, first one is a gift deed. Second is a non-testamentary instrument which create, declare, assign, limit, or extinguish any interest in an immovable property worth rupees 100 or above. So, first of all, the registration is only for immovable properties, and the value of that immovable property has to be rupees 100 or above. So, for practical purposes, all sorts of immovable property is above rupees 100. So, it requires registration. Now, when we say, let's say, non-testamentary instrument, see, non-testamentary instrument, whenever we hear the word non-testamentary, the one thing which comes to our mind is basically wills, and which is true, but non-testamentary does not mean only wills. It includes wills. Okay. The difference between testamentary and non-testamentary is that if a document, let's say document has been made on a certain date, and the effect of the document comes immediately, then it is a non-testamentary instrument. All right. But if the effect of that document takes place after some time, then it is not on. Then it is a testamentary instrument. All right. The only thing is that in wills, that effect, which we say that it will take after some time, takes effect when the person dies. So this is one confusion which pretty much every person would face when they'll study Section 17. Now, as I said earlier, it creates, declare, assign, or limit any interest in the movable property or any instrument which acknowledge the receipt or payment of any consideration for creation, assignment, declaration. That means the things which I have just mentioned, the acknowledgement of money with respect to such assignment declaration, that also need to be registered. Then any lease of immovable property for a period exceeding 1 year or rent which is paid yearly. So that means, let's say if you have a rent deed, okay, and the period for that rent is, let's say, 1 year or more, all right, then it needs to be registered. Okay, that's why all rent deeds, basically what they do is that they are executed for a period of 11 months. Okay, and after 11 months, if if the tenant wants to stay for more, he'll again get that instrument registered, just to save the money which will be charged for stamp duty. And in my state, it is around 4,000 rupees. Then contracts for transfer of immovable property for a consideration as per Section 53A of Transfer of Property Act, which deals with doctrine of part performance, which is executed on or after the commencement of this act. So this we'll study in detail after some time. Now, first of all, understand one thing is that Section 17 talks about documents which need to be registered. So first of all, meaning of document is extremely important, and document is not defined in Registration Act. Okay, they have not defined it, but the expression document has been defined in these three acts: General Clauses Act, Stamp Act, and Indian Evidence Act. So it's better to go by the definition of Indian Evidence Act, because afterwards, whenever there's a trial, the Indian Evidence Act will be referred. But as such, there's no restriction. It's just a matter of practice that advocates have referred to Indian Evidence Act. So a reading of all these three acts will give one thing, will make one thing clear, that there are certain similarities. Okay, that is, the document are matters. It must relate to a particular matter, and that matter must be expressed or described on any substance using letter, figures, or marks, and the purpose of it and the purpose for recording that matter. So for example, let's say that there is a matter, okay, and that matter is transfer of right. So this is the matter. Now this has to be expressed or described. That means it must be written. Only this is the only way how you will express or describe it. Oral things cannot come into play on any substance. Now this can include paper also. This can include even, a stone tablet also, or even a map. All right, using letters, figures, or marks. So let's say that this is a page and the mat is transfer of right, and with respect to this transfer of right, I have written something on this, that let's say A will get certain property for such and such period. So, okay, and A will pay the amount of rupees, let's say 1000. So through letters and figures, and the purpose for recording of that matter, and the purpose which I have just explained. So that is a document. So the document is actually very wide, the definition document. So now we'll come to the individual clauses. This has to be small a, that has become capital A. Okay. So first I said that gift deed. Okay, any gift of immovable property is need to be registered. Now gift as an expression is defined under Transfer of Property Act, and it says that it is a voluntary transfer of movable or immovable property without consideration by without consideration by one person to another. So gift under TPA means movable property as well, but a gift under Registration Act will include only immovable properties. Movable properties नहीं आएगा इसके अंदर. Now gift disinvests all the rights of donor in the gifted property. So let's say that there's a document. Okay, in that document it says that a person is transferred, that a person is gifted a certain property to another person, and then there is another, let's say, line or a covenant which enables the donor, that means the person who gifts the property, to retain rights in that property. So then that will not be a gift, and that will not be a deed which needs registration. All right. So as I said earlier, that even gift deed, the requirement of registration of gift deed is necessary under Transfer of Property Act as well. Okay, so Registration Act only supplements the requirement of registration. All right, but there's one difference, that under TPA, the gift which is to be registered deals with both movable and immovable property, but under Registration Act it is only for immovable properties. So keep this thing in mind. So now we'll come to non-testamentary instruments that create, declare, extinguish, or a right or interest in immovable property. So this is section 17(1)(b), small b. Okay. The only expression of a capital A comes in, that is, section 1A. So that we'll deal afterwards. Now the expression create, declare, assign have different meaning, and because of this different meaning, it talks about different documents. So when we say create, it means that origination of new rights, all right, in a certain property. So let's say that X has absolute title to a particular property. He may be the owner of the property, only then he can have absolute title, and by an agreement he transfers the right in it to another person. Okay, either immediately, that means in present, or in future. Okay, so let's say on attaining majority of the person to whom the right is to be transferred. Now this creates a new right in favor of that person, and such instruments have to be registered. Now we'll come to declare, and declare means change in legal relationship with respect to a right, okay, which exists. So So as I said earlier, partition deed declares exclusive title of a co-person. Okay, now I explain how this word of declares works. Okay, now there is one. Now let's say that there is a joint Hindu family. Okay, and they have a certain joint Hindu family property. Now in the joint Hindu family property, only co-parceners have a right. Okay, so let's say this is A, then father of A and grandfather of A. They will have right to this joint family property. Okay, but this is one, if you have ever studied regarding coparcenary or joint Hindu family, that coparceners have right to the joint family, okay, and they have community of ownership. That means this person, and this person, they'll own the property completely. Okay, before partition, if a partition has not taken place, now grandfather cannot say, okay, even though partition has not taken place, इतने वाले प्रॉपर्टी पर ही सिर्फ लेट्स से ये जो फादर ऑफ है इसका राइट होगा एंड बाकियों पर नहीं होगा, ठीक है, या फिर जो सबसे छोटा बेटा है उसका सबसे छोटे एरिया पर राइट होगा. नो, दिस डज नॉट हैपन. Everyone owns the property in the way as if they have right to each and every particle of that property. Okay, that's why we say that there's community of ownership and community of possession. They possess it also and own it also, as if the entire property is there. But when a partition takes place, this is for the first time that the individual share is basically that they'll get to know their own individual share. So let's say this will go to A, and this, let's say, will go to father of A. Okay, and this then will go to, let's say, grandfather of A, सबसे ज़्यादा property. So in this, what has happened, there's, and now for this a partition deed is made. Now partition deed is an instrument, and what does it do? It simply declares the exclusive right. राइट उन लोगों का पहले से ही था उसके ऊपर, बस खाली वो पूरी प्रॉपर्टी के ऊपर था, लेकिन अब उसको एक्सक्लूसिवली डिक्लेयर कर दिया है. So that's why a partition deed is example when a right is declared. Okay, and it is non-testamentary, because जैसे ही partition deed बन जाती है immediately वो force में आ जाती है. Partition deed बनाई, उसको register कर दिया, and immediately comes into force. A person does not have to wait for a person to die. Now we'll come to assign. Now see, assign means when with respect to a certain property, you give rights to another person. A very common example is basically power of attorney. And if you'll go in any state in India, maximum documents which would require registration would include power of attorneys, sale deeds, and wills. All right. So power of attorney is one of the documents which is registered a lot in all states in India, because हर कोई किसी ना किसी को right दे रहा होता है प्रॉपर्टी को मैनेज करने के लिए. Now when we say assign, a person assigns only limited rights. Okay, अगर तो हमने पूरा right ही दे दिया फिर तो यार वो sale deed की तरह आ गया, right? So that's why power of attorney, because all rights are not transferred. Similarly, another example is a mortgage deed. What does happens in a mortgage deed? Limited rights are given, and what is that limited right? That only if the amount is not paid, only then the mortgagee will get right to the mortgaged property, otherwise he won't get. So the right is limited in the sense that there's a certain time, there's a contingency, and once then contingency comes into effect, only then this whole assignment will come into play. So again, then there are certain ways in which a right can be limited also. For example, let's say that a person has certain property, and by an agreement he says that a bazaar will be held only on certain days. Now this limits the general right of the holder of the land. Right? For example, let's say कोई market है, and this is very common. Okay. नाउ इसके पास यहाँ पर ये बहुत ही बड़ा लैंड है, एंड इसने इसको इन पार्सल्स में डिवाइड कर दिया. And then the person who owns this land, he says that okay, I'll give you the property, you have the right to this parcel of the land, but you can hold your shop only, let's say, on every alternate day. तो यानी अगर मंडे को करा है तो ट्यूसडे को नहीं करेगा, वेंसडे को करेगा, वेंसडे थर्सडे को नहीं करेगा तो फ्राइडे को करेगा, राइट? So he has the rights to the property, but completely near, there are limited rights. So that's how we say that it is limited. And this example I have taken from this case, which is Ganesh versus Sitala Baksh, 1931. Okay, this was pre-independence. And in Registration Act in TPA, a lot of questions or judgments will be pre-independence, because that's when the whole interpretation of it came into play. इतने पुराने acts हैं, 1908 का तो Registration Act ही है. Then we have extinguish. Now let's say that I told you earlier, right, that a power of attorney assigns a certain right. अब ये perpetual तो हो नहीं सकती, unlimited time तो चल नहीं सकती. It has to come, it has to come into, or like it has to come, it has to cease. So for that, either in the power of attorney you can specify the time, or else you can create another document by which you will extinguish a particular right. All right. So, extinguishment of power of attorneys, or simply, let's say that there is a person, okay, and he has proper, and that he has right over a certain property, let's say X, okay, and he has right over this property, absolute right. Now X has no children, nothing. अब ये property का क्या करेगा? So he decide that वो इस property को एक trust को दे दे. All right. नाउ अब जब उसने प्रॉपर्टी ट्रस्ट को दे दी, जो जाके ट्रस्ट किसी पर्पस के लिए यूज करेगी, जो ट्रस्ट डीड के हिसाब से है, एक्स हैज एक्सटिंग्विश्ड ऑल राइट्स इन दैट प्रॉपर्टी. ऑल राइट, उसके सारे जो राइट्स है वो रिवोक हो चुके हैं. सो दिस इज ऑल्सो एन एग्जाम्पल ऑफ एन एक्सटिंग्विशमेंट. ओके, सो ये किसी किसी भी चीज से रिलेटेड हो सकता है. मे बी वो ट्रस्ट ट्रस्ट प्रॉपर्टी से रिलेटेड हो, या लेट्स से पार्टनर्स है, राइट, एंड एक जो पार्टनर है ही लेफ्ट दैट पार्टनरशिप. ओके, सो बिकॉज पार्टनर्स का वो पार्टनरशिप प्रॉपर्टी पे पूरा राइट होता है, सो द राइट ऑफ द पार्टनर, द आउटगोइंग पार्टनर और पार्टनर हु हैज लेफ्ट, उसका राइट जो वो एक्सटिंग्विश हो जाएगा. सो दिस इज एन एग्जांपल ऑफ एक्सटिंग. सो एनी इंस्ट्रूमेंट which deals with such kind of extinguishment has to be registered. If it does not get registered, then section 49 comes into play. Then this is C. Okay, non-testament instruments that acknowledge the receipt or payment of any consideration. Now, in clause B, in 17(1)(b), we said that any instrument which creates the right. All right. Now, if a right is being created, खाली एक पर्सन तरफ से तो क्रिएट नहीं होगा ना, एक्सेप्ट फॉर अ गिफ्ट. दूसरी तरफ से भी कुछ ना कुछ तो कंसिडरेशन है, कुछ कोई तो चीज आएगी. लेट्स से इफ देयर इज अ सेल डीड, ओके, under 17 under 17(1)(b), a right is created which needs to be registered. अब यहाँ से पैसा आ रहा है, so that also needs to be registered. All right. So for this section, this thing is also comes into play. Now for application of this section, there are certain essential which is very important. First of all, there must be an acknowledgement that consideration has been paid or received. Okay, an agreement which say that I will pay consideration in future, that that does not cover, that does not come in under this section. Then consideration must be on account of creation, declaration, assignment or limitation of any title or interest in an immovable property. Okay, for example, and this example is taken from this case, document by a partner relinquishing interest in partnership property need to be registered. Okay, or let's say now another example, you see that that there is an agreement, okay, and that agreement gives certain property, let's say to X. नाउ अगर एक्स को प्रॉपर्टी गई है, एक्स हैज टू देन गिव मनी आल्सो, उसको वापस से पैसा देना पड़ेगा दूसरे किसी बंदे को, लेट्स से वाई, यहाँ वाई आ जाता है. ओके, एंड इट सेज दैट द अमाउंट ऑफ प्रॉपर्टी वाज लेट्स से 1 लाख रुपीज, एंड एक्स सेज दैट आई विल पे यू क्वार्टरली. ओके, 25,000 हर बार पे करेगा एवरी मंथ. Now, this was in the original document. After some time, X says that instead of 25,000, I'll pay you rupees 20,000 every month. Okay, because the condition sahi nahi hai. Now, this consideration which has to go from X to Y, this again has to be registered. Why? Because Section 17 says non-testamentary instrument that acknowledge or receive the payment of any consideration. This example is taken from this case. All right. An agreement that alters the receiving of sale consideration. Earlier यहाँ पे जो 25,000 के हिसाब से जाना था, जो consideration था, but अब 20,000 से जाएगा. So there is an alteration. Must be registered even if seller was entitled to sale consideration as per original agreement. So original agreement से 25,000 था, बस ये change हो गया, इसको alter कर दिया. राइट तो पूरे हैं जो सेलर के थे, सो इवन दिस हैज टू बी रजिस्टर्ड. देन लीज ऑफ इमूवेबल प्रॉपर्टी, इफ ड्यूरेशन ऑफ द लीज, ये लीव नहीं है, इज फ्रॉम ईयर टू ईयर और फॉर मोर देन 1 ईयर और रिजर्विंग अ ईयरली रेंट. सी दिस मीन्स दैट लेट्स से एक प्रॉपर्टी है, उसका जो रेंट है वो एनुअली मिलेगा, हर 12 महीने या फिर 12th मंथ के एंड पे मिलेगा. ओके, एंड ऑफ 12th मंथ. So in that case, such property such instrument has to be registered, and that is why everyone, for let's say if there's a residential lease, वो 11 months के लिए होता है, commercial lease के लिए ऐसा नहीं होता, because वो stamp duty से बच जाते हैं फिर बाद में. But the state government has power. Now this is an exception to this rule, that state government has the power to exempt any lease from compulsory registration if the tenure, that means the tenure of the lease, does not exceed 5 years, all right, or the annual rent from it is not more than 50,000. अगर इन दोनों में से कोई भी एक चीज देन स्टेट गवर्नमेंट एग्जेम्प्ट कर सकती है, बट इसके लिए नोटिफिकेशन स्टेट गवर्नमेंट को निकालनी पड़ेगी. सो बेसिकली जो रेवेन्यू डिपार्टमेंट होता है स्टेट गवर्नमेंट का, दे आर रिस्पॉन्सिबल, बिकॉज रेवेन्यू का जो पूरा है जो लैंड का इशू है, इट इज अ स्टेट सब्जेक्ट. सो अगर कभी आपको ऐसा देखना हो, अपने जो भी स्टेट है उनके रेवेन्यू डिपार्टमेंट की वेबसाइट पे जाना, एंड ओवर देयर एक सेक्शन होगा ऑल नोटिफिकेशन सर्कुलर्स, एंड उसके अंदर यू हैव टू लुक वेदर इन नोटिफिकेशन इज देयर और नॉट. दिस इज वेरी इंपॉर्टेंट केस ऑफ कमर्शियल लीजेस. Now we'll come to section 17(1)(a). Okay. Now see, this deals with part registration for part performance. Now we know that under section 53 of Transfer of Property Act, if consideration for any property has been paid in part, okay, let's say that property transfer करनी थी कोई, and उसका जो total consideration था 1 lakh, या चलो 10,000 मान लेते हैं, और जगह नहीं है, and इसके अंदर 5,000 has been paid, that means part performance has been done, part consideration has been paid. In such cases, the purchasee, the purchaser, okay, he has right to that property. Okay, purchasee cannot say okay because half of the consideration has not been paid, तो अब आपको ये नहीं मिल सकता, अब आप जाओ, नहीं, इसका right create हो गया. However, Section 17(1) states that if a party intends to take the benefit of this part performance under Section 53A, that means अगर उसने payment कर दी है and he gets right over that property, certain rights, not proper rights, but certain limited rights, then such an agreement must be registered. And this section was not there originally. Okay, it is only after 2001 amendment that this provision came into play. All right. So before 2001, the documents, even if let's say part performance had been paid, it required no consideration, it required no registration. Without registration also, simply by taking the defense of section 53A, this has been done. So this simply ensure that there is certain, that to ensure certainty with respect to property transactions. Now there is an exception to this also. If a document simply states that a future document shall create, declare, assign or extinguish any, limit any right, then the registration is not compulsory even if it has been performed in part. Okay. So let's say अब ये जो example है, ये इस case में, अब इसमें क्या हुआ था, that there was dispute between A and B, and that dispute went to an arbitrator. An arbitrator then said that okay, that certain property which is right now in the possession of A will go to the possession of B. However, A has to create a document, he has to execute a document, and with that document only B will enjoy that property, and A will lose, A will, all the rights will be divested of A in that property. So this exception says that if a document simply states that a future document shall create, declare or extinguish any right, then the registration is not compulsory even if it has been performed in part. So in this case, what happened is that A was to give certain property to B, but that property was to go through another document. That means another document creation was required. Okay, so in that case, registration is not compulsory, by which this arbitration agreement need not be registered. Okay, just because the arbitration agreement says that B will get certain property, the arbitration award would say that A has to create another document, and by that document it will go to B. तो ये पहला वाला जो अवार्ड है ये रजिस्टर नहीं होगा, जो बाद में A डॉक्यूमेंट क्रिएट करेगा that will be registered. Okay, so read this case. This is a very landmark case actually. So if possible, do read this case completely. Then section 17(1) says that instrument are, as a result of order or decree of a court or arbitration award need to be registered. Okay, now I'll tell you how. See, a court decree or a order of court does not require registration. All right, but if that decree leads to, let's say, any kind of compromise or any change in composition of property, then that document requires registration. So let's say that there are certain co-partners, okay, and that co-partner files a partition suit. अब या तो co-partner जितने भी co-partners हैं, okay, वो लोग अपने में डिस्कस करके पार्टीशन डीड बना ले एंड देन दे विल एग्जीक्यूट इट. सो इन दैट केस कोर्ट डज नॉट एंटर इनटू प्ले. But if he goes to the court and he files a partition suit, then the court will decree giving certain rights to each and every co-partner. Now once that court has given that decree, simply based on that decree, partition will not come into effect. They have to create a partition deed. Okay, and this partition deed has to be then again registered. All right. Simply that court has said, okay, a decree has been given, so that does not will not entitle them to share to that property. It has to be registered, only then this thing will come into play. But this does not mean that जो कोर्ट का जो वो है, it will have no effect. Okay, in कोर्ट का वो एक ऑर्डर है तो इसका पूरा इफेक्ट रहेगा फॉर ऑल पर्पसेस. सिर्फ जो एक्चुअल पार्टीशन है, जो फैक्टम ऑफ पार्टीशन, दैट विल नॉट कम इनटू प्ले. दैट इज बिकॉज सी, जब लेट्स से पार्टीशन हो जाता है एंड एवरीवन देयर इज अ प्रॉपर्टी एंड एवरीवन गेट्स अ शेयर इन इट, 1 2 3 एवरीवन गेट्स अ शेयर. तो आपको रेवेन्यू, यू हैव टू गो टू रेवेन्यू डिपार्टमेंट, you will get, let's say, registry in your name, then there will be certain mutation entries. In order to these things, a partition deed is necessary, and that is why this clause has been included. So try to understand it from a very practical point of view, otherwise you will never be able to understand that अगर भी कोर्ट ने बोल दिया then क्यों उस चीज की रजिस्ट्रेशन चाहिए, right? Because under evidence act तो any judgment of the court is a presumption that it is genuine if it is certified. So that's why. So it is for these purpose that finally registry हो पाए, exact share कितना है, right, पूरा maps के साथ, and mutation entries हो पाए, इंतकाल जिसको बोलते हैं. So then for that purpose this clause has been included. Now we'll come to section 72, and it says that there are certain non-testamentary instruments which, although create, declare, extinguish any right, they do not require registration. Okay, as given under section B or C. अब B and C में तो बोलता है कि registration चाहिए if it does any of these three acts. Okay, जितने भी है, create, declare, assign, extinguish and limit. But then there are certain documents जिसमें कोई जरूरत नहीं है. So first one is, ये first one था, a composition deed. I'll explain it later. Second is transfer of shares of a company, even if company has immovable property as its assets. So let's say there's a company, okay, and they have shares. Now when you purchase these shares, you get a stake in the company. That means a stake over company's assets, right? So ये उनके जो proper assets होंगे, like literal उनकी जो plant and machinery होगी, okay, let's say उनका जो office space होगा, you will get a right to that. So this law, section 2 says that even if there's a transfer of shares, okay, then obviously you will have right to their immovable properties. So then that instrument does not require registration. Okay, so ये उस चीज को प्रोटेक्ट करता है, so that जो shares का लेन देन है, that becomes easy. Otherwise, for every share purchase, you have to go to the registrar's office to get it registered. Then debentures issued by a company, and debenture deed does not create or assign any right to immovable property. Now see, this case was for equity shares, equity or preference shares. Now debentures are basically loan. Okay, that a company will take a loan from you, from normal person, and not from a bank. Now डिबेंचर जो है ना, वो कोई राइट नहीं क्रिएट करते कंपनी के अंदर. दिस इज अ वेरी वेरी बेसिक फीचर ऑफ डिबेंचर्स इन कंपेयर टू इक्विटी शेयर्स. So debentures issued by a company and debenture deed does not create or assign any right to immovable property. However, because debenture is a loan which I will give to a company, that money has to be returned to me ultimately. And for returning this money, what do companies do is that they created debenture redemption reserve, DRR. ओके, एंड जो पैसा वापस से डिबेंचर होल्डर्स को जाना होता है, विच इज नोन एज रिडेम्पशन ऑफ डिबेंचर्स, दैट इज टू बी डन थ्रू डिबेंचर रिडेम्पशन रिजर्व. So this is basically a security. okay, for debenture holders, and this reserve is held in the form of a trust. So अब ये हो सकता है the company can basically make any immovable property a part of this DRR कि let's say अगर they don't have the proper cash in DRR, so then they'll sell certain property. अब यहाँ पर तो obviously वो आ गए immovable property का and right भी आ गया एक. So again this kind of document will require no registration. Then again, decrees or order of the court, except if such decree has been made on a compromise and comprises of immovable property other than those which are not subject matter of the suit. Now, decrees and orders of a court do not require registration. Understand this, okay? Even without registration, also under Indian Evidence Act, they are admissible. However, let's say that decrees because of a compromise, and a very common example for this is consent by mutual divorce under section 13B of HMA. For this divorce, first of all, a compromise deed. You have to prepare a compromise deed. Okay, that you will let go of all relationships, all marital relationships have ended, and the distribution of property also has been taken place. That means husband जो था उसको इतनी property मिलेंगी, wife को इतनी property मिलेगी. Based on this compromise deed, a person will go to court under section 13B to effect that particular divorce. Right. Now, this compromise has to be registered. Okay. If it is registered, then there's no requirement in the court to go through the entire process of proving that compromise. Right. कि पहले हर एक पार्टी को बुलाओगे, उसको उनका एविडेंस होगा, चीफ एग्जामिनेशन होगा, फिर क्रॉस एग्जामिनेशन होगा. ये सारी चीज को अवॉइड करने के लिए अ कॉम्प्रोमाइज इफ इट इज रजिस्टर्ड, then the decree of the court, then it requires no registration. Okay, if that compromise is based on the decree of a court. Okay, now just for your understanding purposes, do look for provision which deal with registered documents under Indian Evidence Act. Okay, that means how registered documents are admissible under Indian Evidence Act. Look for that section, and what kind of presumption do they raise if a document is registered. Then again, if there is, if government grants you immovable property, no registration is required. Okay, so be it state government or central government. Then again, partition made by a revenue officer. The earlier when we were talking of partition, that was by the co-partners themselves. But यहाँ पे revenue officer आ गया, so basically government ही हो गया, government officer हो गया, IRS officers होते हैं usually, sometimes can be IAS also. So that's why. Then loan given under Land Improvement Act, Land Improvement Loans Act 1883 and 1887, or Agriculturist Loan Act, or any instrument for securing repayment of loan. Okay, so let's say that bank hai, right, and bank has given you a certain loan. ए है और ये बैंक है, अब ये लोन दे दिया, अब लोन एग्रीमेंट तो हो जाएगा रजिस्टर्ड. अब लेट्स से लोन नहीं पे कर पाए, सो देन अब ए ने कुछ ना कुछ तो गिरवी रखा होगा, समथिंग मस्ट हैव बीन केप्ट एज सिक्योरिटी और एज कोलैटरल. सो दिस फॉर दिस अगर फ्रॉम ए टू बी इफ दिस थिंग गोज, लेट्स से ए ने अब लोन देना भूल गया या वो नहीं लोन दे पाया, नाउ द बैंक कैन टेक ओवर दिस प्रॉपर्टी. सो दिस डज नॉट रिक्वायर रजिस्ट्रेशन, कोई जरूरत नहीं है बिकॉज ऑफ section 17. Again, order made under Charitable Endowments Act 1890, vesting property in the treasurer of charitable endowments or disinvesting of such property. Okay, so endowments are basically religious trusts. अगर वैसा सा कुछ है and it is for charitable purposes, so any vesting of property does not require registration. Okay, basically they have a separate deed, so that is completely different. So now effect of non-registration of document, as I said earlier, it is given under section 49, but since the time has taken a lot of time, so this we'll discuss in some other video. But please read section 49. Okay, so read section 49 and section 18 as well. Okay, section 17 is very lengthy, so that's why it takes a lot of time. Thank you.